Hello, everyone, and thank you guys so much for joining us today for our weekly Friday webinar. Today, we're going to be talking on So You Have a 21-year-old. We've done this in the past. So really excited to be talking about it because it is an important topic. I am accompanied today by our awesome managing attorney, Ruby Powers. Round of applause. She's going to be giving us all of her expertise and everything that she's known as an attorney with all her expertise throughout her years working as a board certified immigration attorney. So a little bit on our attorney. She's been licensed since 2008. She founded the firm in 2009. She's a board certified immigration attorney. She is also a
I think we lost you.
Okay, sorry about that. Not sure what was going on here. Zoom had a small glitch, but just continuing where we left off, a little bit on our attorney. If you guys heard me, I'm not sure, but I'm going to reiterate it just once more. She has been licensed since 2008, founded her firm in 2009. At some point, she ran the firm from Dubai. I mean, what does she not do? She is an author of Build and Manage Your Immigration Law Practice, and recently founded a Power Strategy Group in 2020. So we're really excited about all her accomplishments and all that she does. So I'm going to let her take it away with her learning objectives.
All right. Well, thank you so much, Dana. And I have a great team. So that's the only reason we're able to pull off all these great things to help our clients. So we're going to, they're just going to give you some feedback, some advice. This doesn't take the place of a consultation, but you feel free to ask us any questions you have in the chat, or you can always give us a call, have a consultation. So the reason why we did this is because if you have a U.S. citizen child 21 or up, you are an immediate relative. You are an immediate relative, and that could mean you could procure a legal permanent residency green card. But there could be some complications. So we just want to go over that because sometimes people come to us at the last minute. The kid turned 21, their child turned 21, and they think that it's just going to be easy, but there could be some complication that might even make them ineligible. And so we wanted to go over those. So get that information out there so there's not a surprise. So the difference between adjustment of status versus consular processing, talking about the legal entry or parole in place, and then alternatives to not having a legal entry, and then some inadmissibility concerns. So, feel free to ask any questions, or Dana, help me out if I start talking like a lawyer and
Of course.
Okay. So basically there's all these different types of considerations of what's an immediate relative, and then there's also this whole visa bulletin, and you're like where you are on the whole hierarchy of the visa being available. But an immediate relative is generally considered the spouse of a U.S. citizen, the minor child of a U.S. citizen, if the child's not already a citizen already, which usually is the case, but some cases not. And then also the parent of a U.S. citizen. And so you also can be a step parent as long as that qualifying relationship existed. Generally means that they had to have been married right before the child turned 18. So we're only going to talk about that immediate relative. The rest of these, let's see, spouses of LPRs, married daughters of U.S. citizens, those are not immediate relatives, but those are different categories. So So when you have a child that's a US citizen and you're the parent, step parent, and you have the qualifying relationship, then you could potentially either do what's called the adjustment of status or consular processing. But we have to look at some things. And let me just go back about the whole child thing, because things now with surrogates or in vitro, or I don't know, there's some a little bit more complications recently that are make it a little bit more unique. And USCIS is still trying to, Department of State still trying to keep up with all those unique things, manners to create that relationship. But what's really important is that the parent's name is on the child's birth certificate, and that if the parents were, if, for example, a father, the one or whomever did not give birth to the child, was not, and they were not married to the parent, the one who did give birth to the child, then you need to be looking at things like establishing the paternity, or the parental relationship. And I don't want to go into complicated things here, but like it could get complicated. So we look at the birth certificate, and we also check to see if the parents were married at the time of the birth. And if not, then we need to start looking at some other considerations, like was the relationship established through their life, and we look at where was the child grow up, what was the establishing paternity law at the time of where the child was living, and also we might have to get some DNA tests done. So those are all in the realm of possibility, and so when things get a little bit more complicated, definitely you'd want to have an experienced immigration attorney helping you out figure those things out. But doesn't mean it's impossible, just means you might need to have a little bit more help. So big picture, if you can file inside the country, inside the US, then you're talking about adjustment of status. And you generally would have an interview with your local field office. Sometimes those interviews are waived, meaning they don't have them. And they say, hey, you're good. We don't need to have an interview. We're going to approve you without that interview. But if there's any complication or some question about who the parent is and if that relationship existed, or if there's any other blemish like an inadmissibility, crimes, things like that, then you're probably going to have an interview. The other way is through consular processing, and that's the one you deal with the State Department, and you would do all the petitions and then wait for an appointment at the local consulate embassy, and then you would be able to come in if all is well. So generally when we have these consults, people are preferring to do the adjustment of status. They're here in the country. And the biggest question we have is, did you enter legally or not? So the general gist of it is, if you entered legally, you have, like, say, a tourist visa, an F1 visa, H1B, something, I don't know, you have something that you entered legally. If you have a immediate relative, which is your US citizen child who's 21 or up, then even if you overstayed that visa, it's okay. But this only when you have an immediate relative. So that's the general scenario that we see from folks, is that they might have entered legally and they have a US citizen child and now they're ready to file. But if a person did not enter legally, then we have to look at some other options. For example, maybe they were paroled in. Another thing could be maybe they got a parole based off of some other visa petition they had. We've seen this as well. Or maybe their child is in, one of their children is in the military, and can apply for what's called a military parole in place. And that is establishing that you have that relationship with the child, or maybe even the spouse, and that they are in the military, active, ready reserves, or have been in the military in the past, and they were not dishonorably discharged. There's a couple other little details there, but basically, then you can apply with the I-131 form and to your local field office and show the establishing relationship in the military, and then you could get what's called a military parole in place, and that counts, if you will, like a legal entry for the adjustment purposes. So when we're talking about getting a green card, you're here in the country, we really need a legal entry. And if not, we could look for maybe military parole in place, or maybe you have parole, or there could be one of these alternatives or exceptions that we could use. Now, one of the biggest ones that might still be available, but this is something back in the past, 20 plus years ago, is that if you were the beneficiary or derivative of beneficiary of a petition, I know I'm using some legal jargon here, Dana, so keep me honest. But basically, if someone petitioned for, let's say, you, or maybe you are on a petition of your parents before or by April 30th, 2001, you might be able to use that and pay a fine and use that as like a legal entry. And we call that in 245I. Now, not everybody has those. Those are old, but there's a lot of them out there in the past that we might be able to pull them off and use them. Now, sometimes people don't know who petitioned for whom, they don't have a record, but we can figure that stuff out. We can do a Freedom of Information Act request, try to get a copy of that. Takes time. That's the whole point of this webinar. It's because we don't want you to come here when your child turns 21. We want you to come here maybe when your child's 19 or 20, maybe 19 and a half, because we want to have a plan. And maybe you're eligible for something else that's even better or faster or something like that. You don't have to wait till the child turns 21. So the ideal equation is you enter legally and you don't have any problems with the law. You didn't leave and come back legally, or you just have one illegal entry and your child's 21. That's the ideal scenario, but that doesn't happen very often. Because, that's a long time that a person might have entered many years ago, depending. Or maybe your child has been here for a while. They recently got their naturalization through marriage, through someone else, and now they're wanting to petition for you. So that still could work out for you. Okay, so going back to you don't have a legal entry. Well, we mentioned the military parole in place is an option. That can take maybe a few months. So you want to make sure that you have that time to do that. The other beautiful thing about the military parole in place is that you get work authorization for that year while you have it. So that can give you an alternative option. The other thing is DACA. Now, the oldest DACA recipient right now is 40 in about a month, 40 in a month. Can you believe that? We've had DACA for so long and we still don't have a DREAM Act, but we're hoping that'll happen one day.
Crossing our fingers.
Fingers crossed. So maybe you're eligible for DACA. Now, the DACA doesn't mean it's a green card. No, it doesn't. But you can apply for a travel permission, and then you could go get that travel permission, get back in legally, and then have someone petition for you. So that could work as a possibility because we have initial filing for DACA and we have travel permission for DACA going on right now. The other option is 245I, which I mentioned. We might also be able to do a provisional waiver if you entered illegally, hopefully one time, and you have a U.S. citizen, legal permanent resident, spouse, or parent who could be a qualifying relative. We might, if you're in immigration court, we might be able to go for 42B, cancellation of removal. And also there's the U visa, which can take quite a long time, but there's always something to review. Now, there's other potential options, but if you don't have a legal entry, it really does limit your options. And maybe also TPS, temporary protected status. It's opened up for Venezuela this year, which by the way has a deadline of early September, which is soon approaching. And also, some other, let's see, that we covered a lot of the territory. Maybe T visa, a trafficking victim. There's also this other wild card that's super old, but it's called registry. And if you have been here since January 1st, 1972, you can show proof that you've been here and you can get a green card from that. And also reform, which we will always be hopeful and will advocate and aim for. And so that's something that I'm just going to tell you, we all would love a comprehensive immigration reform. That would be great.
Yeah.
But what's probably going to happen in many cases, it's going to be lots of little piecemeal changes. And that's what we're seeing here. Trump administration was very restrictive, and now Biden administration is releasing a lot of those things. Even just this week, they made a change to immigration court can now administratively close cases. And for long, I don't know, a year or so, we haven't been able to. So that was a change this week alone. So we're seeing a lot of these changes take place, which is why you should always have a consultation. If you've been told you're not eligible for something, you should always have a reputable, experienced immigration attorney talk to you about maybe once a year and double check, because there's been a lot of changes in the last 7 months, honestly. So, when let's say you entered legally, let's say your child's about to turn 21, or maybe you meet one of those other exceptions like 245I or military parole in place, we still need to review some other stuff. Like, do you have a criminal matter? The best thing to do if you're in need of a review of that is to have the immigration attorney review that with you, bring your record or email it, fax it, whatever you want to do. We still have a fax number. And give that criminal record to us so we can review that, because this is the biggest misunderstanding. Things can get dismissed. It still has a conviction for immigration purposes potentially. So we have to figure out why it was dismissed. Or maybe even if it happened in another country, it doesn't mean it didn't exist. So we have to look at that. If it was expunged, it still could be a conviction for immigration purposes.
Yeah.
So we look at the records and make sure that you're eligible still, or if you need a waiver for that. And then if you've had multiple entries, like you came in legally, but then you left and then you came in illegally, then that could where we can get into some big issues there. So we have to look at all those dates and know what you did. And then also if you ever were removed or deported in the past, we need to, generally that's a big hurdle to overcome. But right now there's a prosecutorial discretion memo that's basically saying there's a lot more leeway and discretion for judges and trial attorneys to be able to be open for us to reopen court cases, to terminate court cases. There's a lot more discretion right now. So if you've had an old removal order, this is, another great time to talk to an immigration attorney about those things. So we don't want to go too technical, detailed for you, but we wanted to give you like a big picture idea. The biggest takeaway should be don't wait until your child turns 21. If you've been waiting for that to happen, make sure that you get a consultation. The other thing to note is that it could take time, whether you have to collect records, you might need to finalize a criminal matter, reopen a court case, or maybe you need somebody else to get a green card to be like more of like a domino effect where you can get yours as well, to be eligible for a waiver or what have you. So I hope that all made sense and wasn't too confusing. Okay, good.
You did a good job, Ruby.
All right. So feel free, I'll let you let them know how they can stay in touch with us.
Of course. Well, thank you so much. And I'm just gonna, put this out there. Like Attorney Power said, don't wait till the last minute, guys. 19-year-old, 19 and a half, bring them in. We got it. Trying to get you guys prepared. But just a little bit on us. You can follow us at Ruby Powers Law on all of our social media handles. We have our Tuesday Powers Hour, where you can join us live. Attorney Powers gives us updates on immigration news, trends, or updates that have been going on for that week, or any new policy updates. So tune in on those. And then, of course, our Friday weekly webinars where you're able to register and ask us questions live. We will continue to do those. And just a little bit on that, our July webinar schedule, our next webinar is going to be on Immigration Court 101, motions to reopen. And attorney Cynthia Milian is going to be joining us for that one. Our next webinar after that on July 30th is everything you need to prepare for your consular interview. Very important stuff. We're hoping a lot of movement in immigration courts. So we're trying to keep you all prepared. And yeah, I would also suggest you all subscribe to our newsletter. We have a newsletter that goes out bi-weekly and it's jam-packed with all the information that you all need to know in regarding to immigration and local news that are important or could be important to your case. But that's about it for today. I'm going to be dropping down the link for you all to register for our upcoming webinars if you all would like, or share them with friends, family who are interested in immigration law. But thank you so much, Attorney Powers, for giving us this information. And we really do hope to see you all on the next one.